Judgment in the matter of Jones against Birmingham City Council and another.
This appeal concerns injunctions to prevent gang-related violence. Gang-related violence is a problem encountered across the United Kingdom, but is often concentrated in the larger cities. It's often connected to drug dealing and may also involve firearms offences, obstruction of justice, and other illegal activity which threatens public safety and the rule of law. While this activity is usually directed towards other gang members, persons not associated with gangs can be exposed to danger and to harm. Birmingham is one city in the United Kingdom which has been heavily affected by gang violence. The Guns and Money gang is one of the gangs linked to violence in Birmingham for over 30 years. In February 2016, following investigation by the West Midlands Police, proceedings were commenced by Birmingham City Council against the appellant, Mr. Jerome Jones, and 17 other defendants, all of whom were said to be members of the Guns and Money gang or a rival gang. Birmingham City Council applied to Birmingham County Court for injunctions to prevent the defendants from engaging in gang-related violence and drug-dealing activity. The injunctions were requested pursuant to Section 34 of the Policing and Crime Act 2009, the 2009 Act, and in the alternative under Part 1 of the Antisocial Behaviour, Crime and Policing Act 2014, the 2014 Act. Interim injunctions were granted against the defendants in February 2016. The appellant then applied for the injunction claim in his case to be transferred to the High Court, where he applied for a declaration that it was incompatible with Article 6 of the European Convention on Human Rights. The application concerned the question whether Article 6, Paragraph 1 of the Convention on Human Rights, as given effect within the United Kingdom by the Human Rights Act 1998, requires the criminal standard of proof, that is, proof beyond a reasonable doubt, to be satisfied in respect of proof that a person has engaged in or has encouraged or assisted gang-related violence or gang-related drug-dealing activity within Section 34, subsection 2 of the 2009 Act, and proof that a person has engaged or threatens to engage in antisocial behaviour within Section 1, subsection 1 of the 2014 Act. In the High Court, Mr. Justice Burton held that the proceedings in this case were not in respect of a criminal charge and did not require the application of the criminal standard of proof. The trial of the injunction action was then held in the Birmingham County Court in 2017. Judge Wall applied the civil standard of proof, namely the balance of probabilities, to the question of whether Mr. Jones had been involved in gang-related drug-dealing activity and therefore satisfied the first condition of Section 34, subsection 2 of the 2009 Act. Judge Wall concluded that the condition was satisfied and he granted an injunction against him pursuant to Sections 34 to 36 of the 2009 Act. The injunction which was granted against Mr. Jones included provisions preventing him from entering a large area in central Birmingham, associating with or contacting 10 people named in the injunction, and participating in music videos containing material which might relate to gangs operating in Birmingham. Mr. Jones then appealed the order of Mr. Justice Burton to the Court of Appeal. The Court of Appeal held that proceedings under Section 34 of the 2009 Act do not involve a criminal charge within Article 6 of the European Convention on Human Rights, and for the threshold conditions prescribed by the 2009 Act for injunctions in respect of gang-related drug dealing and the 2014 Act for injunctions in respect of antisocial behaviour, the civil standard of proof was compatible with Article 6 of the European Convention on Human Rights. Mr. Jones appealed to the Supreme Court against the decision of the Court of Appeal. It is no longer argued that the proceedings against him involve a criminal charge within Article 6 of the European Convention on Human Rights. The principal issues on this appeal have been, first, whether the Court of Appeal erred in law by distinguishing and declining to follow the decision of the House of Lords in the Queen on the application of McCann against the Crown Court at Manchester, that the criminal standard of proof should be applied in proceedings in respect of an antisocial behaviour order under Section 1 of the Crime and Disorder Act 1998, the 1998 Act, and in failing to apply that standard of proof to applications for injunctions under Section 34 of the 2009 Act and Section 1 of the 2014 Act. And the second issue was whether the Court of Appeal in any event erred in law in holding that the criminal standard of proof did not need to be applied in order to satisfy the requirements of fairness under Article 6, Paragraph 1 of the Convention on Human Rights when considering whether to make an injunction under either or both of those provisions. The Supreme Court dismisses the appeal, unanimously holding that Article 6, Paragraph 1 of the European Convention does not require the criminal standard of proof to be satisfied in respect of the evidence of gang-related activity or antisocial behaviour when a court is considering applications for injunctions under the 2009 Act or the 2014 Act. The Supreme Court further finds that under Part 4 of the 2009 Act and Part 1 of the 2014 Act, Parliament has devised statutory schemes to govern the making of these injunctions which conform with the requirements of a fair hearing under Article 6 of the Convention on Human Rights. There is no authority from the European Court of Human Rights which supports the proposition that a fair hearing under Article 6 requires the application of the criminal standard of proof in circumstances such as those in the present appeal. In fact, Article 6 does not lay down any rules on the burden or standard of proof, which are essentially a matter for domestic law. While it would be open to the Strasbourg Court to develop its jurisprudence on Article 6 so as to require the application of the criminal standard of proof in such circumstances, there is no sign in its case law to date that such a development is likely. The McCann case is not authority for the proposition that antisocial behaviour within the 1998 Act is required to be proved to the criminal standard. The standard of proof under Section 11A of the 1998 Act was the civil standard of proof on the balance of probabilities, and to the extent that any reasoning in the McCann opinions is to the contrary effect, it is wrong. McCann does not support the proposition that the criminal standard of proof must be applied to the requirements of evidence upon which a gang injunction can be granted under the 2009 and 2014 Acts. In respect of both those Acts, Parliament has expressly provided that the standard of proof applicable in relation to the granting of gang injunctions shall be the civil standard. In the light of this express provision, there is no room for the courts to decide that as a matter of common law fairness, the criminal standard should be applied. The adoption of the civil standard was a deliberate step which Parliament considered was justified by the seriousness of the behaviour addressed by these injunctions and the purpose of the statutory scheme, namely to prevent and protect against gang violence. Furthermore, Parliament has incorporated into the 2009 Act and the 2014 Act procedural safeguards which secured the fairness of any trial in relation to the granting of a gang injunction. The standard applicable to the relevant issues under the 2009 Act and the 2014 Act is, therefore, the civil standard. The court's task is to determine whether, on the balance of probabilities, the conduct identified took place. Court is now adjourned.